Welcome back to the channel, viewers. This is episode 85, and in this episode, I'm going to deal with the principle of double jeopardy in criminal proceedings. But before I do, my usual disclaimer. This is not legal advice, should not be construed as such. For legal advice, please contact a competent attorney of your choice. Welcome back. The principle of double jeopardy, or the double jeopardy rule, is an important legal protection for individuals against the abuse of the state, abuse of the government, or abuse of the Crown Prosecution Services, the Director of Public Prosecution. It stops the police and prosecutors from repeatedly investigating and prosecuting an individual for the same crime without good reason. The double jeopardy principle is best described, in my view, as a common law concept in criminal law, which bars criminal prosecutions for the same offense after a person is acquitted or convicted of that offense. English law has had the double jeopardy rule for over 800 years. But this was partially abolished in England, Wales, and Northern Ireland by the Criminal Justice Act of 2003. Scotland followed in 2011. Therefore, in very limited circumstances, a person who was acquitted of a crime can now be investigated and put on trial once more for the same offense. In April 2005, when sections 75 to 85 of the Criminal Justice Act of 2003 came into force, consequently, a person can face a retrial if 1. The Director of Public Prosecution authorizes it. 2. There is new and compelling evidence, such as DNA evidence or witness evidence. Maybe an eyewitness has now come forward that was not available at the previous trial. Or if the person is being accused of committing a qualifying offense. The qualifying offenses are all particularly serious offenses, which in the main carry a maximum sentence of life imprisonment. Now, let me say very hastily and probably reassuredly that this law, or the Criminal Justice Act of 2003, is not applicable in the Turks and Caicos Islands. So just to recap, before the reform to the law in England, Wales, there were 2 principles at common law which prevented a person being tried for the same offense or substantially the same offense. The first is known as act of war, acquit, and the second is known as act of war, convict. This is French, meaning previously convicted or previously acquitted, and I hope I have done justice to the pronunciation of these terms. These principles provide a bar to a child, or should I say a retrial, in respect of the same offence of a person previously acquitted or convicted of that offence. And I dealt with those two principles when I dealt with commonly used terms in criminal proceedings in a previous episode some time ago. I will leave a link, or I will link that video somewhere up here or up here. So why did the principle of double jeopardy change? Well, it was reasoned and argued that if a person is wrongly convicted, there is an appeal process to remedy this error. If a person is wrongly acquitted, there is no such process. This was leading to some high-profile examples of justice being denied. One such example was that of the case of William Dunlop. Dunlop was accused of murdering a female in 1989. He stood trial twice for the offense, but on both occasions the jury were unable to reach a verdict. Rather than seek a third trial, the prosecution offered no evidence and a formal not guilty verdict was recorded. After being cleared of the offense, Dunlop admitted committing the offense. The evidence of those admissions was enough for him to be convicted of perjury. However, he could not be retried for the murder itself, and so could only be sentenced for the offense of perjury, receiving a sentence of 6 years imprisonment. Following the change in the law, Dunlop was again prosecuted for murder. He pleaded guilty and received a life sentence. So, what is the legal position, or what is the law on double jeopardy in the Turks and Caicos Islands? As far as I am aware, there is no statute in the Turks and Caicos Islands reforming or abolishing the common law principle, as was done in England, Wales, and Scotland. Therefore, it is my considered view that the common law position prevails in the Turks and Caicos Islands. Therefore, if a person is acquitted of an offense, it is the end of the matter, and he or she does not have to look over their shoulders, fearing that they may be charged a second time for the same offense. It is my considered view that that is so, even if new and compelling evidence such as DNA or eyewitness evidence come to the attention of the authorities after the acquittal. And it is my view that in such circumstances, the Director of Public Prosecution would be powerless to authorize a prosecution in those circumstances. Now, someone listening to this episode may point out, and do so correctly, that in the Turks and Caicos Islands, the Director of Public Prosecutions Office usually withdraws cases or often no evidence on a particular matter only to recharge or refile the case against that person for the same offence or substantially the same offence sometime later. While this assertion would be correct, this is not to be confused with the double jeopardy principle. The withdrawal of a case against a defendant, unless it was done with prejudice or the offering of no evidence against a person charged with a criminal offence, does not constitute an acquittal. The Constitution of the Turks and Caicos Islands empowers the Director of Public Prosecutions to withdraw or discontinue a case against a defendant even before a trial commences. In this scenario, the case or the matter has not been tried on its merits, meaning that evidence has not been called and tested in a trial. No verdict has been rendered either by a jury or a judge. Therefore, the defendant is merely discharged by the court, which is not the same as being acquitted. In this case, it is legally permissible for the Crown or the Director of Public Prosecution to refile the charge at a later date, subject, in my considered view, to legal arguments of abuse of the court's processes premised on any relevant ground under the principle of abuse of process. I hope that I did justice in distinguishing a withdrawal or discontinuation of a case against a defendant and an acquittal. Further, I hope that I have done justice to the subject matter of double jeopardy. Here is where I will end this episode for today. If you learn anything useful from this episode, please give it a thumbs up, and I will see you shortly in another episode. Cheers.